judgment regarding the counterclaims for delay damages and excessive waste of lumber. So I've reviewed the parties' briefing and your fact statements and the attached exhibits, as well as the relevant cases that you cited. I'll start with you, Mr. Palachek, whenever you're ready. And I'm sorry, I have to double check because I just had an argument. Is it Palasek or Palachek?
So the old country, Czechoslovakia, it's Palachek. So you were right on as far as the original pronunciation. We say Palasek here in the United States.
Okay. Your preference is Palasek?
I don't have a preference, but sure, let's go with that.
Okay. All right. Well, I just want to make sure I'm pronouncing it the right way going forward. All
You're
right,
good.
whenever you're ready.
Thank you, Your Honor. Okay, so I think I'll just outline our reply arguments and reserve most of my time for rebuttal. I mean, I think our arguments are pretty straightforward, clear. We essentially are saying that the contract's clear, the contract terms are clear. And as a result, we would ask you to be able to rule summarily on those two issues that you outlined, the excessive waste of lumber and the delayed damages. What we're saying with regard to delayed damages, we're not saying that McShane cannot bring a delayed damages claim in its countersuit. What we're saying essentially is they can't calculate the delayed damages claim under their extended general conditions model because of the liquidated damages provision in the contract, which because of its language is an exclusive remedy for calculating those delayed damages. So, both parties have experts on delay damages. We're not saying that can't be brought. We have our delay expert, they have their delay expert. Certainly delays are going to be part of a trial. So we're not saying that, we're saying the calculation of that damages. So just to be clear, that's why it's a motion for partial summary judgment. For a number of other reasons, it's a motion for partial summary judgment. So let's dig a little bit into those facts. Very clear that the liquidated damages provision is exclusive of any other calculation of delayed damages because of this clause, notwithstanding anything to the contrary. That language appears without any qualifiers as to what else Mr. Woods might argue, such as the pass-through damages or anything like that. There's no such qualifiers in this addendum, in this term in the addendum, and notwithstanding anything to the contrary, there's a plain meaning to that, Your Honor, that is essentially undisputed, and that is to the exclusion of any other language in the entire contract. At page 4, we argue that in the case law, it's well known that such language overrides conflicting provisions of any other section. And again, on page 5, we say there's no qualifier to our language. It's very clear. And, all of the arguments Mr. Woods makes fall at the foot of notwithstanding anything to the contrary. That's our argument. On page 7, we're essentially saying, look, they can't argue or calculate any delayed damages that might be asserted by them. Sorry, any delays that might be asserted by them at trial. They can't calculate using that extended general conditions model. At page 8, we argued the freedom of contract. And certainly McShane had the right to exclude that provision, had the right to qualify it or any other rights. It did not do that. So we stand on the face of the contract documents and on the clear terms of those contract documents related to the calculation of delayed damages. On page 9, there's an abandonment argument as well. I think it's a 1931 case. I didn't see that it had any real help with the facts of this case. And my impression of the abandonment argument is more like a failure of consideration argument. I can see in other contracts where someone asserts or inserts a liquidated damages provision and that doesn't perform. Then you're saying, well, wait a minute, that's not fair. That's essentially a failure of consideration, no performance. Well, in this case, we don't have that. It's undisputed from the facts before you that U.S. Framing was 90% completed with their project. There's no abandonment claim that could make any reasonable sense as a genuine issue of material fact with regard to the delayed damages motion that we filed. I can turn to excessive waste now and just outline that.
Well, to clarify, you are not suggesting that the limitation, the liquidated damages limitation in the addendum caps them at $500 a day in damages to the exclusion of other types of damages, consequential contract damages. That limitation, you agree, is just as to damages claimed for delay.
Yeah, I think we say that. I think we say they can pursue actual damages.
Right.
Yeah. No, I think that's. I think essentially that would remain to be seen what they might present at trial. But yes, with regard to their delay expert, and the calculation of damages related to delay, let's say they're asserting 250 days of delay. The only calculation we're saying that can be used is the $500 per day for a delay damages claim.
And so on the excessive waste of lumber claim, when lumber, the use of the lumber, the storage of the lumber, and in this case, the allegation that there was a misuse that required replacement or repair, why isn't that consequential actual damage associated with the alleged breach?
I think I would argue it this way. And it's really inherent, we parse words all the time in our business. The claim is excessive waste of lumber. And that's key. Excessive means something somewhere. McShane doesn't have an expert to opine that U.S. Framing excessively wasted its lumber based upon some standard or some opinion by an expert. So you have to look to the contract terms to find a standard from which the trier of fact could argue, okay, that's been deviated from. That's an actual damage related to obligations under the contract. It's kind of interesting, Your Honor. This is a COVID era project. And back during those times, obviously we see a lot of cases related to COVID era contracts. This one's interesting because, sort of the background, what McShane did here was different than typical cases. What McShane tried to do here is ensure that they could purchase all the lumber themselves at a certain cost because of the fluctuations of supplies in the construction industry during the COVID era. So they assumed that risk. They could have done a turnkey project with U.S. Framing, where U.S. Framing is supplying labor and lumber, labor and materials. They didn't do that. So what McShane did was they assumed the risk of hiring, subcontracting, if you will, with this Matthews Lumber Company, okay? And they came up with a lump sum amount that they were going to pay Matthews for the lumber on this project. The key for us is that, McShane can do that. And if McShane wants U.S. Framing to be obligated to that standard, it needed to include that contract somewhere in our contract. Typically, you don't have to do that. I think McShane just didn't go back to our subcontract and say U.S. Framing is subject to or incorporate by reference the Matthews contract. There's nowhere that I don't think a trier of fact can go to find within the four corners of the documents a standard that U.S. Framing was obligated to meet with regard to how much lumber they could use. Different, perhaps, argument might be made as to damage to lumber. You know, a separate argument that something happened or U.S. framing didn't handle something in particular as damages. That's different than saying they had this, McShane saying we had this amount of lumber that U.S. framing was obligated to complete the entire project for that amount. There's nowhere, you can't find that in these documents. You can't find that anywhere. And you can see how they stretch, and McShane knows it's an issue because you can see in the declaration of Ken DeBartoleben, and I think that's at paragraphs 32 and 33 where we assert sort of like a motion to strike, or that the two of those statements are inadmissible under the parole evidence rule, in which Mr. DeBartoleben is trying to bring in the Matthews lumber number into the U.S. framing McShane subcontract, where he says, well, U.S. framing knew about this number. They were part of the entire process of McShane coming up with this number. If that's true, there's nowhere in the four corners of the document that if McShane wanted U.S. framing obligated to the help that they gave, if they did give help, we think it's not an issue for the court to even consider because it's outside the parole evidence rule, because our parole evidence rule takes the Corbin's view, and I apologize for not citing to a case. I think it's pretty black letter law.
I'm very, very familiar with Taylor versus.
Yeah, that's the one I was going to reference. Certainly under the Corbin view, extrinsic evidence can be brought in, but only if there's an ambiguity. We're saying no ambiguity, Your Honor. Clearly McShane had the opportunity to put the Matthews contract by reference, all like with all the other contract documents under that provision that we all read all the time. What are the contract documents under which, in this case, U.S. framing is obligated? Matthews appears nowhere. Nothing. And that was up to McShane to bring that in if they really believed that they relied upon U.S. framing for that number. So we're saying there's no standard that a trier of fact could look to. Matthews is out. Matthews has nothing to do with us. There's nowhere that you could say, okay, this $250,000 number or the amount of lumber that is associated with that lump sum contract that McShane had exclusively with Matthews is somehow now an obligation of U.S. framing. Does that make sense? How I'm saying that? Okay.
All right. Thank you, Mr. Palasek. Mr. Woods?
Yes, Your Honor. Would you like me to start with the excessive waste argument or the liquidated damages argument?
I think your focus probably ought to be on the liquidated damages argument, and I'll tell you it's because I am struggling with your argument there because of the notwithstanding any other provision to the contrary clause in the addendum. Go ahead.
Okay, Your Honor. Well, I'll start by addressing the notwithstanding clause. So U.S. framing's reply cites case law describing what the effect of the notwithstanding anything clause represents. And that case law represents the fact that the significance of the notwithstanding language is to reflect the drafter's intention that provisions of the notwithstanding section override conflicting provisions of any other section. That terminology does not mean that we take a tunnel vision approach to the provision and read paragraph 10 to the addendum in a vacuum. The other sections, namely the pass-through clause and the other liquidated damages section, they're not in conflict. We're suggesting that the court review the paragraph 10 to the addendum in light of the other provisions so that it can inform the court's understanding as to the party's intended meaning for the terms, namely the liquidated damages clause. So here, U.S. Framing's motion for partial summary judgment asks the court to apply its interpretation of a contract clause to cap the amount of damages McShane can be awarded at trial. And to prevail on its motion, U.S. Framing must be correct in its interpretation of the contract, and the clause must not be reasonably susceptible to more than one interpretation. So I'll begin with McShane Construction Company's understanding as to the intent as to the provision, and then I'll address why U.S. Framing's interpretation is not valid and just patently incorrect. So this lawsuit arose in large part because U.S. Framing's poor performance caused the entire construction project schedule to be delayed. When a subcontractor delays the project, the general risks incurring two categories of damages. The first is its actual delay damages. This is salaries, fence rentals, bathroom rentals, and any other cost that's incurred on a monthly basis. And the second is owner-assessed liquidated damages. That is stipulated sums the owner is entitled to when a project's completion is delayed. So there's these two buckets of damages, and the contract between McShane, the general contractor, and the subcontractor expressly provides that in the event of a subcontractor caused delay, McShane is entitled to recover both buckets of damages. Liquidated damages assessed by the owner and its separate actual delay damages. And when you read the contract in harmony with that clause, the clause signifying that the subcontractor will only be liable for up to $500 per day liquidated damages, it's merely a limitation on one of those two buckets of damages. It's a limit on
where do I find support for that interpretation in the contract language itself, though? In particular, in the language of the addendum, the provision 13.2.
Yes. So I'm sorry, are we looking for support within the paragraph 10, the addendum, the clause that subcontractors are relying on in support of its motion?
I need support for it in the language of the, and I'm sorry, I'm trying to find it. The copies I have, they're not that great. The notwithstanding paragraph or provision.
So I can't share my screen. I would share it if possible.
I will make you a presenter. And I do have both of your fact statements open. So if you can tell me what